Hi, this is attorney Ricky Malik. Today, what I'd like to talk to you about is the new Deferred Action program, also known as Deferred Action for Childhood Arrivals. You may hear the acronym DACA, D-A-C-A. This program is also known as a watered-down DREAM Act. It's not the DREAM Act as we all hoped it was going to be, but it's a step. And today we want to go over what the requirements are for this program. First of all, it's designed for young people, those aged under 31. So essentially you had to have been born under the age of 31 as of June 15th, 2012. Secondly, you needed to have come to the United States before your 16th birthday. You have to prove and have to have continuously resided in the United States since June 15, 2007. That's 5 years from the announcement of the program. And you were physically present in the United States on the date of announcement, which was June 15, 2012. Also, you've got to be somehow in school or a graduate of school. So you can be currently in high school. You can be in a GED, that's a General Educational Development Program, or its equivalent. In fact, you can even be in certain types of ESL programs, as long as that, ESL being English as a second language, as long as that ESL program is a prerequisite to your placement in a post-secondary education or job training or employment position. And then the burden is on you as the applicant. If you are trying to qualify through, let's say, a non-traditional means, such as an ESL program, the burden is on you to prove that that program will lead you to such placement in the education, job training, or employment position, and that that program has demonstrated effectiveness. Programs that also qualify are the education, literacy, or career training, but again, the burden is on you to prove that that program will then lead to post-secondary education, job training, or employment. So it's a very flexible program that it's not just limited to high school and high school graduates, which is, I think, a positive thing. The other very important requirement is you cannot have been convicted of a felony. A felony is defined by the statute, the law of the state or the federal government, that is generally a punishment or a crime where you can be punished with 1 year or more of jail. Now, that doesn't mean that you actually have to have been sentenced to 1 year. It means that potentially the criminal judge could have given you 1 year or more because of that crime. So if you have a felony, you can't qualify. Secondly, if you are convicted of what's called a significant misdemeanor. There was a lot of speculation about what this is, but now it has been defined. Okay, a significant misdemeanor is a crime that involves domestic violence, or it could be a crime involving sexual assault or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or driving under the influence. That was the one, the driving under the influence, that I think there was a lot of hope that that would not be counted as a significant misdemeanor, but indeed it is. DUIs are significant misdemeanors, or any crime, even if it's not in one of the ones that I've just stated, that you actually served 90 days or more in jail. So it could be not one of those, but the judge felt whatever you did was serious enough that he had you in jail for 90 or more days. The 90 days does not include any time on maybe pre-conviction or detainer if there's an ICE detainer placed on you. Lastly, you cannot have been convicted of 3 misdemeanors that occurred at different times. So if you were convicted of 3 misdemeanors that occurred out of the same series of events or the same date and time, that's not going to count as 3 misdemeanors. But if you have 3 separate misdemeanors, whether significant misdemeanors or not, that'll disqualify you. In terms of driving offenses, because we talked about the DUIs, driving without a license has been stated not to be a significant misdemeanor. So if there are non-traffic related offenses, you should be okay. So just to go over the criminal part again, felony, either or. A felony, you can't qualify. A significant misdemeanor, you cannot qualify. Or 3 non-significant misdemeanors. That being said, there has been information put out by the Department of Homeland Security that the criminal history is a factor to be considered. The absence of criminal activity or convictions, or the inclusion of criminal activities, is a factor to be considered, which seems to leave open the possibility that even if you have committed a DUI, depending on the other equities and circumstances of your case, you may still qualify for this deferred action. What I would suggest, if you're unsure of if you qualify, whether the type of program that you're involved with qualifies, or even if you have any criminal activity or criminal convictions is going to pose a problem, I definitely consider consulting or meeting or even hiring a very qualified attorney to help you through this process. We're always available, and we're looking forward, and we are beginning to help a good number of people. I can be emailed at dream, DREAM, at rmlegal.com, or you can call us toll free at 877-577-VISA. Thank you very much. This again is Attorney Ricky Malik, and we look forward to helping you and assisting you. Goodbye.